aggravated and mental distress, 250, and then $500,000. What is it? 2026, 2017, $500,000 for punitive damages.
What is that now?
It's 12 eggs. Welcome to Water Cooler Justice. I'm Chris Robertson, and I've been practicing employment law for over 20 years, helping clients resolve disputes and navigate challenges at work.
And I'm Sarah Goodenough, Chris's legal assistant.
Today we're joined by two highly esteemed panelists, Muneeza Sheikh and Ellen Lowe. Muneeza is one of Toronto's most sought-after lawyers, specializing in employment and human rights law. She founded her own law practice to advocate for those who have experienced human rights violations, especially for women and marginalized communities, and provides solutions for both employees and employers. You may have caught her many appearances on media platforms like CBC, Global, and City TV, where she regularly provides insights. Muneeza, welcome to the show. We're so glad to have you on.
Thanks, Chris.
Returning to Water Cooler Justice is Ellen. She's the managing partner and principal lawyer at Ellen, Lowe & Co. Employment Law. After her beginning at Gowlings, becoming a partner at Whitten Lublin, and 10 years of HR relations and employment law practice, her own firm was born. She is a member of the Toronto Lawyers Association, Women in Law, and the employment section of the Ontario Bar Association. Ellen is also one of my go-to sources when there's a case that I just can't remember or I can't put my finger on. I know if I call Ellen and describe the facts, she'll give me the case back in 30 seconds. Ellen, welcome back to the show.
Thanks, Chris, for having me and for the invitation.
Sarah, why don't you take us through the details of today's case?
Okay, so today we're going to look at Galea versus Wal-Mart. This was a particularly long case, so I'm going to do my best to summarize as much as I can, the 90-something pages into a quick summary. So Miss Galea, the plaintiff, began her career at Wal-Mart Canada in the position of district manager in training on September 3rd of 2002. Now, at the time of her termination, which was in November of 2010, Miss Galea's job title was Vice President, General Merchandising, a promotion which she received back in August of 2008, in which her base salary went from $237,000 to $257,000 plus additional bonuses. Now, over the course of her 8-year tenure at Wal-Mart, she masterfully climbed the ranks, receiving multiple promotions and was widely considered a rising star in the company. Ms. Galea had an impressive laundry list of accomplishments, recognitions, and favorable opportunities, which reflected her outstanding performance and impact at Wal-Mart, not to mention the various promotions, salary increases, and earned bonuses. However, despite Ms. Galea's performance history, at a meeting in January of 2010, then President and CEO of Wal-Mart Canada, David Cheesewright, told Galea he was removing her from her role and considering whether to reassign her to a subsidiary in another country. Now, this would be a lower position without any clearly defined duties. All attempts to define and solidify this new role in the subsequent months were unsuccessful. During the 9-month period leading up to her termination, the plaintiff explored pursuing opportunities abroad with Wal-Mart, began a professional development program at Harvard University, and went so far as to learn Spanish in case she was requested to move to Chile. However, after returning from Harvard, the plaintiff was informed that her employment was terminated. Galea continued receiving her base salary following termination. However, these payments unexpectedly ceased at the 11.5-month mark. Galea's covenant not to compete agreement, entered into in 2005, provided for Wal-Mart to pay her for 2 years following a dismissal not deemed for cause. This engendered Galea to pursue legal action against Wal-Mart for breach of contract, in addition to punitive, aggravated, and moral damages. So I'd like to hear your thoughts on the case.
All right, well, I'll start us off then. This is not strictly a wrongful termination or wrongful dismissal case because Galea was on a lockup agreement where there were restrictive covenants in exchange for compensation that would continue to flow during the restrictive covenant period, which the employer then unilaterally decided to stop paying. That aspect of the case is, I think, more straightforward. If there was a breach of the agreement and the money's recoverable under the agreement, I understood that. What fascinates me about this case is that significant moral and punitive damages were awarded, and I'm wondering Ellen and Muneeza, if you've cited this case in the past, if you looked at this case, and your thoughts about the awards more for the moral and the punitive damages as opposed to the wrongful dismissal. Muneeza, you want to start?
Sure. Thanks so much, Chris. And I just want to say that I'm super excited to be on, and the fact that I'm on with Ellen, two female-led law firm, super cool. Sarah's here. I mean, Chris, I guess it's fine that you're here too, but
Yeah, thanks for having me.
But in any event, so thank you for that. I think for me personally, the most interesting aspect of the case, as as you noted earlier, prior to you hitting the record button, all those juicy tidbits that you had was really, it's the sexiest part of the case is really the very significant moral and punitive piece, right? The rest of it, there's a roadmap of sorts. And I do believe that the judge is, pretty thoughtful in terms of methodically setting out exactly where the rest of the damages flow. And then I find, on the punitive and moral piece, it's like he tries to set the roadmap, but then when he gets there, it's still a surprise nonetheless. That's my view. Now, I think the question you asked is it a case that we've cited? So for me, I'm a lawyer that does a lot of human rights work, a lot of employment work and then a lot of employment work intertwined with human rights issues. I think the aspect of it that is probably the most frustrating, I'll say, for me is I do have clients. Most of my clients are quite sophisticated. They read, they send me case law. I think, I did a funny LinkedIn post about it not too long ago where they're like, you should read this case. And I'm like, thanks. But they'll refer to a decision like this and they'll say, well, what happened to me, was so much worse. And Chris, I think you mentioned, one of our friends, Tatha, who had posted this decision about a $25,000 tribunal reward in relation to age discrimination. And, it's difficult because you think of someone who's worked somewhere for X amount of years and then is explicitly or, perhaps in an implied way told that you simply can't work here anymore because you're too old. And then what you get for that is $25,000. I mean, that doesn't necessarily negate or, undermine the experience in the Wal-Mart case we're focusing on today. But I think the biggest issue is this massive disparity between what the courts can do and what the tribunals do. And I say as a human rights lawyer, it's just one more potential roadblock to persuading your clients to go to the tribunal to get an award for sometimes what can be some pretty egregious behavior.
Ellen, any insights or thoughts?
Yeah, I'm just nodding along because the first thing that struck to mind was, and to echo Muneeza's comments, I don't cite this case that often. I think it's a really helpful case in that it's almost a textbook in terms of providing guidance in terms of what's the state of the law, which frankly needs a little bit of updating and has been updated since because this is now an older decision. But what are the bases upon which you might seek extraordinary damages? Where I see a challenge is exactly where Muneeza sees a challenge as well, where clients will send me this case regularly. Right. And they will point to it and they will confuse themselves. And sometimes they will try and confuse me in terms of, well, how come she got $250,000 and you're telling me that I should debate a settlement proposal that has $25,000? Why is that? And I have to say to my clients, I'm usually pretty forthright. I'm a bit of a data nerd. So I try and mine as many cases as I can. I have spreadsheets. I have Excel in terms of I do. I'm a nerd, as you know.
I love it. That's great.
I'm jealous. I'm not like that at all. I want to be like that.
Because eventually we're going to get some guidance or some awesome AI will come in and we'll be able to type in the facts and it'll tell us what the general damages award should be or what the aggregated or punitive or moral damages should be. But we don't have that yet. So we're going old school analog data entry. But it is such a massive disparity that I really struggle with it. I think Minnie's in the same way that you do. And that's even outside of the human rights context. That's just pure civil litigation. And so having to explain or trying to explain why that award could be quite literally zero weight in a mediation. But if you want to really swing for the fences, it might be $250,000. That's really hard to explain. That's really, really hard to explain to clients. And there's really sometimes, I think, not a lot of objectivity with respect to why it's one thing versus another. What I will say is that when I look at sort of trends, I suppose, if we're going to call them that, when we're looking at sort of the types of bad behavior, I would say that strict legislative violations tend to be on the low end of the scale, right? So there may be small awards. We're probably thinking like HBC and POL, where it's $10,000, where there was an inadvertent or an unintentional breach of the ESA. There wasn't a payment within 7 days of the interruption of earnings. It was something that was maybe unintentional and small. Where I think the distinguishing feature here is, and it doesn't really help anybody, is that there does seem to be almost intention. And I'm reluctant to bring that into this discussion, but I do think that it does make a difference when you're dealing with a large, sophisticated corporation. Did they intend to hang her out high and dry for as long as they did? And then the judge, I think quite rightly, going back to sort of a rubric analysis, looks very carefully at manner of termination, pre-termination conduct, post-termination conduct, litigation conduct, and then whether or not any sort of medical evidence was required for that. And that, I think, is helpful in terms of if we're going to look at a large ask for extraordinary damages, how can we code it, right? Can we code it in manner of termination, pre-termination conduct, post-termination conduct, litigation conduct? Is there a way to group that as a whole?
Now, in this case, no medical evidence was actually provided, right?
Right.
And so, again, in a human rights tribunal context, I'll often deliver some form of medical documentation. For example, perhaps a pharmacy history report where there's no history prior to the events of treatment for symptoms associated with mental distress and anxiety, and then post events, you'll see prescriptions for the holy trinity of zopiclone, lorazepam, and what's the other one? Ciprocol? I can't remember. No, clonazepam. Sorry. We'll edit that out. But in any event, when the pharma history report is blank, and then all of a sudden it's littered with drugs and changes in prescription amounts as doctors work with the patient to try and get them feeling like themselves, it always surprises me when I find a decision like this, where there's no medical history. What are the courts punishing here? They're really punishing the behavior, not so much assessing the harm. Would you agree? Thoughts?
I would agree with that. And I mean, it takes me back to the conversation that I often have with clients when we're talking about some of the heads of damages that we've set out in a claim and our ability, if we end up going to litigation, to achieve the same. And what I often say, and I imagine the two of you may say some variation of this, is look, it's not just about doing the bad thing. The court has to be persuaded that you intentionally did the bad thing. You could do the bad thing, but ultimately, if the court makes the finding that it was a breach of a policy, as Ellen had mentioned a moment ago, you're not going to be attracting the same type of damages as, was set out in this case, where in my view, at least, and I'm happy to hear from the two of you, this judge seemed pretty intent on punishing some pretty deplorable, and I think he used the word deplorable behavior on the part of Wal-Mart, right? So it was not just the manner of termination. And when talking about the manner of termination, it was not just the events leading up to the termination, but it seemed a little bit, at least in my view, if I was, counsel for Wal-Mart, I would feel probably a little bit prickly about the litigation strategy being looped in. I don't think those were the explicit words that were used, but I think it's understood that what happened post, termination, that's when we get involved. So that would make me feel a little bit prickly, just in terms of the heading that it all sort of was swept under in terms of damages associated with post-termination conduct. But in my view, I think this judge was intent on making an example of Wal-Mart. I do personally think the behavior was incredibly deplorable. And it's interesting because I actually have used this case, and this might surprise you, sometimes when I'm dealing with employer counsel who just don't want to respond. Like, we've got a timetable, they don't want to respond on, affidavit documents, we're supposed to get, examinations completed by a certain date. And I will often say, and I think I've pulled it from the decision, like, your deafening silence is not okay. Like, your client could potentially, sort of be punished as a result of your failure to respond.
I think that's interesting. I mean, for me, like in a wrongful dismissal, I know that sometimes, especially older management counsel, feel that time is on their side to a certain extent, that, delay imposed will lead to mitigation or may lead to a post-termination fact that's helpful. In this case, remember, she was on a lockup agreement, right? And they just arbitrarily stopped paying her. And so there really wasn't a whole lot of reason to delay. Either the agreement was enforceable or it wasn't. Either they repudiated the agreement or they didn't. The thing that I found fascinating was this was a 28-day trial.
With a motion in advance.
With a full motion, yeah. 28 days. I don't think I have ever had a wrongful dismissal matter that has gone longer than 7 days. I mean, maybe you guys have had some longer ones, but 28 days.
Not 28 days.
Not 28 days.
Unbelievable. Unbelievable.
I've never had an arbitration or a human rights hearing or a civil trial at 28. It's a monster of a trial, and it's a monster of a decision, right? It's 308 separate paragraphs.
Well, yeah. At what point does the judge stop writing things down? Right? If it isn't a jury trial, right? Which I don't believe this was.
No, it wasn't a jury trial. The other one you want to talk about, Bouchard, was, but this one is...
Oh, fair. I didn't know that. Well, we'll move on to our second act, I guess we'll call it. Sarah, you want to read us in here?
Perfect. Yeah. So we'll touch on Bouchard. So it is important to note that Galea is not the first case in which Walmart was ordered to pay damages for its conduct. Now, in Boucher, Walmart was found liable, which went up to the Ontario Court of Appeal. In this case, an employee was continuously belittled and criticized by her manager. When she attempted to resolve the issue by appealing to her higher-ups, she was informed that the investigation had rendered her complaints unsubstantiated. This treatment had caused the employee to suffer immensely, citing loss of appetite, insomnia, and weight loss. Yet the manager in question persisted and even increased the abuses, causing the employee to ultimately resign. Now, after resigning, the employee brought in action for constructive dismissal. The Ontario Superior Court found Walmart and the manager liable for wrongful dismissal damages in the amount of $1.5 million in punitive damages, aggravated and intentional infliction of mental suffering. The sum was lowered to $410,000 in the Court of Appeal, but this still remains one of the highest amounts awarded within this context. So what do you think about this repeated history from Walmart?
Muneeza, you're shaking your head. Why don't you go first?
Because you know what? I'm just
Muneeza's
over
got feelings.
it.
Yeah.
I've got feelings, guys.
Yeah.
I've even got feelings in my toes. But I'm just over it. I'm just over like these and I think when you look at the decisions, you can feel the frustration from the judge as well, who's writing the decision, right? Like I think you've got these massive employers. There's public accountability. You put yourself out there as we're this big corporation, but guess what? We're looking out for the little guy. We want to make sure our prices are X so you and your family can afford it. We're accessible to everyone, and that extends so far. Your brand extends so far beyond your customers and clients. I think, it infiltrates obviously into, whether you're treating your employees well. So I think, what we see in these decisions, it truly does fly in the face of the core values of what Walmart how they try to publicly present themselves. So, and they're not the only example, right? I mean, so often we see these cases with these big companies with these public, facing profiles that are so different from the manner in which they treat their employees. So I do have feelings about it. I strongly believe that these sort of massive awards, and massive on this side of the border, right? In the US, I mean, like there's conduct that's far less egregious and it can attract, damages in similar categories that are significantly higher. But I think this is our Canadian judges saying, stop doing what you're doing. And again, I just wish that would be something that could more comfortably translate into the adjudicative space when looking at our administrative tribunals. I just don't think that we're there yet.
Ellen, thoughts?
I have lots of thoughts. I have lots of thoughts on the Boucher case. Like Galea, and like Muneeza, I have sophisticated clients who send me this case all the time. And when you read through it, this poor person, Meredith Boucher, was exposed to some really egregious conduct at the hands of, in particular, her direct manager and then Walmart writ large. What I think is really interesting, and I want to pick up on something that Muneeza said, yes, the judge in this decision chastises the conduct. But I think what's more important is, and a massive distinction, is that the trial of a decision here is a jury. It was a jury trial that found that Boucher had been constructively dismissed and awarded her, I think, like 20 weeks of salary and $1.2 million against Walmart, of which like $200,000 was aggravated damages. And $1 million in punitive damages. So regardless of what the judge thought, that's what a jury thought this poor person deserved based on that conduct. Now, at appeal level, there's a whole bunch of really interesting conversations and guidance, in my view, about double recovery, the intersection of intentional infliction of mental suffering and any double recovery for punitive damages. But it's one of the only instances that I can think of, and maybe you guys can think of other ones, where a jury of someone's peers looked at this conduct and was like, well, $1.2 million is the appropriate price tag. Like, it's
I can't think of any others.
I'm curious, do you guys often select jury trials where you've made large damages claims?
I don't actually, but this case would certainly. I mean, it's definitely an interesting perspective, but I would worry, despite this decision, about some of the legal arguments, right? Particularly when you're dealing with legal arguments, there's no such thing as a slam dunk constructive dismissal, right? So I would be a little bit worried about putting something like that in front of a jury, but this is a case that clearly proves me wrong.
Right. Yeah. Well, the constructive dismissal, it starts with a resignation, right? So the employer's first defense is you get nothing.
It's been a really long time since I threatened a jury trial. I'm with Muneeza in that some of the finite legal issues I think are probably better suited for judge alone. But I also think it's interesting just to compare this case in a, sort of the quantum of damages to circle back to our earlier discussion about sort of human rights, right? Because this level of award has not seemed to have translated into any sort of similar damages award at the Human Rights Tribunal.
Well, so I have some thoughts about that. I mean, is it because the procedure is different?
I don't, it's, oh my, are we amongst friends? Can I be?
No, it's all, we're all friends here. You
Chris,
and
you should
me
get
and
out
Ellen
your pen
and
be like, this is what I'm about to edit out.
You and me and Ellen and all of the internet. We're all friends here. But yeah, let's have a talk.
I do not think that our vice chairs at the tribunal level, not all of them, of course. I think we've all been dealt various hands there, but there are scenarios where, I'll do a mediation and I'm just like, really? Like, I don't think there's the level of understanding when it comes to the legal issues. There isn't the same amount of pressure. I don't think that they are confident enough to make these sort of decisions. I mean, they often, more often than not, deal with facts that, at least in my view, are pretty egregious. Like, if I was to split my practice and look at my straight human rights cases and the fact scenarios that I'm dealing with, the fact patterns that I'm dealing with in comparison to my employment cases that have human rights issues intertwined within those cases, I would say the straight human rights cases that would be better streamlined towards a tribunal. Those facts are incredibly concerning. But it's so interesting that if I was sitting with both sets of clients, the type of money that we would ask for, what a claim would ensue, would be so wildly different than what we would put in at the administrative tribunal level. And if you think about it, that's incredibly concerning. So basically, for our clients who have dealt with human rights violations, you literally will do better if there's an employment issue intertwined, so you can punt yourself out of the administrative tribunal lane, which I think is grossly problematic. And, that's why oftentimes when I'm dealing with a straight human rights issue, I will say to my clients at the outset that our best chance to get you a good deal is going to be at mediation. Because I almost promise you that whatever we get at the tribunal level, if this goes to the end of a hearing, it's not going to make you feel good.
Yeah, I mean, aside from forum selection, and I echo a lot of what Muneeza says, like there's a very strategic determination of where you want to go, which forum you want to be in with your client and why.
Right.
We could probably have a whole podcast about that.
Absolutely.
Section 46 alone, right?
There you go, right? I worry a little bit, and what I think maybe like personally upsetting is that when I look at awards that are granted in civil court, and then I look at what I respectfully think is a paucity of damages awards for really disgusting pure human rights violations, it's hard to compare, right? So, for example, in Alberta last year, 2024, there's a case, Olivia Pascoe and Strong versus Gorcy, GURSOY, 2024, AHRC 45. I think it's the highest human rights award ever in Alberta. And the person got what? $25,000? $50,000? Like, and there was an express invitation to have sex with him and provide him with a baby. Like, this is a person who is in a vulnerable position in a workplace, and the amounts and damages awards, sorry, I correct myself, the damages award was $75,000, but it's the highest ordered by the tribunal for any one human rights complaint to date.
And in our tribunal, there's no costs, right? So out of that damage award comes the cost of the complainant's representation. That's what doesn't make any sense to me. You would think that the damages award at the tribunal would be a little bit higher, just in recognition of the fact that carrying a representative through to the hearing has a cost associated with it. I get, there's not supposed to be cost consequences, but the reality is that, there aren't supposed to be cost consequences so that vulnerable people feel comfortable coming forward.
Absolutely.
Not to protect bad behavior.
Yeah, or to deprive vulnerable people from good, adequate representation.
That's a tough one. I think that's a harder one to wrestle with, whether or not, tribunal should be awarding costs. Some do, some don't. I do think that there's probably some room, within the sort of realm of, are we doing justice, to consider that those costs exist, right, in fashioning an award. And so that's one that I've always sort of struggled with a little bit. Like, I would have expected, the lower end of the range of a human rights tribunal award to be higher than the lower end of the range of a court award, simply because the court has the power to award costs if you've been the successful party. So, so that's one of my thoughts about the human rights tribunal. The other thought is, like you, if I can combine a discrimination complaint with a wrongful dismissal, I think that's always preferable for my client, right? Because in addition to having more opportunities to recover, there's advantages in the mediation process that we'll get into in another episode, maybe. Coming back to Wal-Mart, is it fair that a particular employer that, perhaps has had a judgment or two that have not been favorable in an employment or labor context should be subject to higher awards? And do you think that was a factor here? Is Wal-Mart, in hockey parlance, a repeat offender, so they get a bigger suspension?
It's an interesting idea. I know the Ministry of Labor has recently amended all of their penalties sections, right, for repeat offenders. So, no, when I look at the two cases with Wal-Mart, both judges give quite reasoned analyses as to why they have issued the awards they have awarded. And I'd like to think that conduct is being evaluated as against the case law and based on the facts. But it's an interesting intellectual exercise, which is, if the Ministry of Labor has done it in a way that if you are a frequent flyer or a repeat offender, you're going to be dinged with higher damages. Without saying it out loud, do courts do the same thing? And I don't know. I genuinely don't know the answer to that.
Well, one of the purposes of punitive damages is to deter the behavior in future, right?
Absolutely. And I think and I agree with you, Ellen, and Chris, to your point. If the whole intention behind the award is to, deter the behavior, and then it happens again, and of course there's going to be the level of analysis associated to the, specific set of facts. I think that is something that any court would take into consideration. And that, of course, doesn't absolve them of their obligation and responsibility to, again, set out that roadmap so we can get there from there. But nonetheless, should it be offensive that the court would consider an earlier decision of a massive award? And again, I think the type of employer has a little something to do with it. And I think Wal-Mart, at least in my view, the public-facing image is something that I would be surprised if the court didn't take into consideration.
Yeah, and in our particular case that we're looking at today, Galea, right? I believe the fellow's name is it Cheese Right? Sarah? Cheese Right?
The manager.
The top executive, right? He admitted on the stand that he arbitrarily adjusted the performance assessment from the top Q1 down to Q5. Yeah, it's an admission at trial,
with
right?
no explanation. Oh, was it a trial, Chris, or was it an examination? I thought it was an examination.
Was it not on the motion in advance of the trial?
But there's a full-on admission on the record. Yes. I did this, right?
With no explanation.
And with not a lot of explanation, right? And so one thing I do feel is that when I read this decision, sometimes I feel like maybe I'm not getting the whole story. That there is whatever the motivation or what caused the breakdown in the relationship between the supervisor and the employee. It doesn't really leap off the page here. I'm wondering if there's more to the context. If there's some evidence that didn't make its way into the decision. Hard to imagine. It's 103 pages. But that was something that I thought was interesting too. Was that I never really got a sense as to how the relationship broke down, which frankly ties into the damages, right? That it's not when it's not clear from the case why the plaintiff was subjected to the behavior, I could understand why it would be shocking to the plaintiff.
If I can go in a different way, which I think is interesting and sort of like tickles the back of my brain, is when we're talking about punitive damages, I do wonder, and again, this is not written in the decision anywhere, it's not part of the matrix of the decision-making process, is the ability to pay, right? And so this is a large multinational corporation. They have lots of money. Presumably they have very deep pockets. And so can they more easily bear, or should they more easily bear, a large punitive damages award in that quantum, which a smaller organization would not be asked to bear, even if it were the same conduct? And that's, again, it's not argued, it's not in there, but I just wonder about it when I look at both of the cases as against.
That's interesting. I mean, I think the damages award are a rounding error for Walmart, regardless.
Yeah.
Right, like whether it's 1.2 million or 410,000, it doesn't really make a significant difference to their profit and loss.
Like it's such a significant amount of money in our employment world, but you're absolutely right, Chris. I mean, in the grand scheme of things, it means absolutely nothing. Now, I will say, to your earlier comment about, I think it was Mr. Cheese, right? But my view, at least, was, given the lack of explanation as to why that performance rating was adjusted, my view, at least, was, look, the judge saw this as really just setting the stage for a departure, and all good faith, all desire to, treat her fairly just went out the window. And again, maybe it's my hyperactive imagination, but I almost imagined a scenario where they had a really good relationship. They were close. They didn't know what they were going to do with the role anymore. And then she kind of just became a thorn in his side. And I could almost see him through the conduct becoming increasingly annoyed. So like I said, hyperactive imagination, but that's what jumped out at me. Or else if you're not providing an explanation, like that's treating an employee incredibly unfairly to change their performance rating. And I think it was such that it precluded her from being able to be considered for any type of a promotion. I mean, that's disciplinary in some nature, or preventing her from being able to expand within the company, and then basically saying to her, if my memory serves me correctly, you can either take a severance package which didn't honor the NCA terms, or you can take some, ding dong position that, has a probationary period attached to it. Right. So I think it was all of it sort of lumped in together. Something happened to Mr. Cheesewright, and it wasn't good, guys. It wasn't good.
Well, imagine if she had taken one of those options, unaware of the Q5 rating and subject to some new terms which may have governed the termination of her employment, right? So actually, I did have one more question. I want to get your thoughts. Do you think that awards are going up, or do they seem stuck? To me, sometimes when I read the case law, it feels like these awards are stuck. The awards don't seem to be moving to me. Is that your experience as well?
Yes.
100%.
Any thoughts on why that might be?
Allergic to appeals, I think, too. I think a lot of the trial judges are just petrified of an appeal.
I mean, that's one of the things that happened post Honda v. Keys after we got rid of Honda Wallace damages, right?
Right. Because
the notice period was difficult to appeal when Wallace damages were tacked on the end. Ellen, thoughts?
I can't explain why, but I can tell you based on data, they're not going up. Like if I pull the damages,
you've got the spreadsheet.
Of course,
you've got the receipts.
But like if I pull the spreadsheets from the HRTO damages chart from, like I started tracking this, I don't know. I have at least at my fingertips 2019 through to 2024 in terms of the HRTO damages chart. They haven't changed, right? Terrible behavior at the tribunal is still $20,000 to $25,000. So frustrating. It is so frustrating in terms of trying to advise your clients about what a realistic prospect of success looks like, how much it might cost them, how long it's going to take. It is a little bit infuriating, even when you're a data nerd like I am.
And then actually, Galea is great for outlining this. I believe in one of the heads of compensation, they only sought, I think, 50% of the bonus. And the court goes on to say, if you had asked for more, we would have awarded more. And so one of the problems I have with damages claims is how much do I write them for? What my experience tells me a tribunal or a court might award, or for an amount that's at the top end of the range because maybe this particular case is Galea. I mean, what are your thoughts on that? When you're writing your claims, do you think about a top end maximum? Do you write for the maximum? Do you write damages claims specific to the facts that are in that claim?
I write for the maximum generally in terms of like the contractual claims. And then on the damages piece, again, you kind of want to stay in the realm of what's reasonable based on the set of facts. But, sometimes you'll get a case where you just dream big and see where it takes you.
I'm not afraid to dream. I'll let the internet know that.
Yeah, I think it's a conversation. Again, I think it's a strategic conversation you have with your client in terms of to some degree, what do they want, right? Like I personally have a practice of trying to, probably similar to you, Muneeza, making sure that the contractual damages are properly accounted for, right? We're not just setting out round numbers to set out round numbers. But yeah, and that can be a really tricky conversation at the pleadings phase with a client, which is, well, you're right, Galea pled for and received $250,000 in aggravated damages. Do we want to put that in there? Does that push us into big kid court rather than simplified procedure?
Right.
What are the costs and benefits of even doing that? But then being very careful, you're right, Chris, because there is an admonition in paragraph 192 of the decision, which is a single sentence, which is, quote, pleadings matter, end quote. And I was like, oh.
Yeah. Ouch.
I was like, I would have given you more, but, quote, pleadings matter, end quote. I was like, oh, harsh.
Yeah.
Okay.
Yeah, like, if you didn't know what the outcome was and you were reading that, like, you'd be worried about the final paragraph of the judgment, right? If you were following along for the first time or getting those reasons for the first time.
Yeah, or as counsel and normal human beings as counsel, just being like, oh, goodness, like that doesn't give us any flexibility for any error whatsoever.
Well, I mean, and we have that problem now in settlement too, thanks to the Court of Appeal, right? The Preston v. Service case, like, now, when an employer won't adjust their standard form universal blanket release from all claims, across the multiverse, whether now in an alternate dimension or in future, and your client has, I don't know, $5,000 in a DPSP somewhere, if you can't get a carve out from opposing counsel, what are you supposed to do, right? I think, increasingly employment law is becoming such a technical practice. Right?
It is.
Can I make my usual plug? And that I think we need. Feel free to fight me on it. I would really like to see, in the same way that we have a commercial list, I would like to see an employment list.
Oh, support,
Like,
100%. Oh my goodness.
Why are we giving a separate set of rules and separate set of access to large corporations who have millions of dollars, but my client who needs to get this income to make her mortgage and buy groceries can't get an 8:30 appointment. So I want specialized people in a specialized tribunal or a civil setting. I want an employment tribunal. Period.
How could anyone disagree with that? Like, that to me is like baffling. That is 100%, Ellen.
Yeah, preach.
I'm not just saying this
there.
because I want all of her spreadsheets. I'm not saying it just because of the spreadsheets. I mean, if she wants to give them to me, she'll
proprietary.
give them.
I absolutely agree with that, Ellen. The only question I have, and this came up on one of our earlier episodes, is how many cases are there actually? How many wrongful dismissal cases are there that actually make it to trial? I don't know.
Well, they're also not making it to trial because clients are, and Ellen, you'll agree with this, and Chris, you probably will as well. Clients are like, I'm done. It doesn't matter anymore. It just doesn't. I will literally take whatever's on the table because I cannot stand one more minute. And realistically, it's like another year. They're just done.
Or if you could say to them, there's a specialized tribunal, we will probably be in and out within the next 6 months. I think there's a lot of cases already. I think you'd have even more people who are seriously interested in pursuing not only their contractual rights, but making genuine questions and inquiries about moral and aggravated and extraordinary damages if there was a tribunal and we could get this sorted out for the benefit of everybody way faster.
But would you want a tribunal's award, or would you prefer the amounts that the courts are currently awarding?
I don't know why can't it be both? Again, why do we have a commercial list but not an employment list?
I hear you, but I mean, I'm just saying. Currently, we just had a conversation about how tribunals, seem to be reluctant to rise to the same level as courts when dealing with bad behavior.
Okay, so
right?
Again, if it can't be a tribunal, maybe it can be just an employment list. So it's in civil litigation.
All right. I catch the distinction.
A fast-tracked list. That's
all
it.
Right,
With a guarantee that our judges are specialized in employment law. I mean, I know we're trying to come to an end, but I just had the most frustrating case conference with a judge who definitely was not specialized, in employment law. And again, the thought that, I could have a complicated employment law case end up in front of, and I guess we could probably have a whole other episode based on that alone. But yes, I think the specialized judges is a critical piece.
That's interesting. So I don't know about non-specialized judges. I do know that when I've appeared before judges that practice in the field of employment law, that the trial is fast, it's efficient, and we get down to it, in terms of what are the facts that are in dispute and what are the real issues, for determination. It does move very quickly. I agree. When you get a judge that has practiced in the field for a significant period of time.
Absolutely.
So, to both your points, I think that's interesting to me. Probably going to wrap it up at this point. We know I let the cat out of the bag. I think we already said that the amount was $200,000, or was it $250,000 for moral damages and $500,000 for punitive?
Yeah,
Yes,
moral
that's
damages,
correct.
aggravated and mental distress, 250, and then $500,000. What is it? 2026, 2017, $500,000 for punitive damages.
What is that now?
It's 12 eggs.
Ugh.
12 eggs. Look at you.
Any last comments on the case, guys?
No, I'm busy trying to find the inflation calculator online so I can figure out to meet this question like in real time.
As long as Ellen emails me afterwards and tells me, that's it. But yeah, no, this was a good one. Definitely one that I think we're going to be talking about for a while. I mean, the big question is, has Walmart learned its lesson?
No, because it would have to pay in today's money. It would have to pay $622,799.92 if this were a $500,000 in punitive damages award today. So
Wow.
Look at that. That's the way to end it.
Yeah. All right. Well, so I think that's where we're going to conclude today's discussion. I want to thank you guys for a great discussion. It was super fun, very passionate. I loved having a different perspective. Again, I hope you'll both come back and join us for other episodes. We're going to try and mix and match people so that we get different personalities and positions coming together, so that we get a good sense of where it coalesces. Where the Venn diagram overlaps, as Andrew I think said.
Thank you, Chris. It was a lot of fun. Thank you for including me.
And I want to thank Sarah for keeping us on track, and our listeners for tuning in. If you like the episode, subscribe, leave a review. If you've got a case you'd like us to discuss, or if you'd like to share your own story of workplace drama, and we love stories of workplace drama, email us at watercoolerjustice@gmail.com. Till the next episode, thank you very much.